Good afternoon, everyone. Welcome to the final webinar in the current series this week on issues that we have seen arising from COVID-19. This webinar is titled COVID-19, Where Do You Stand? And focuses particularly on UAE issues. In this webinar today, we will look at 4 practical scenarios and investigate the rights and obligations of the relevant parties. My name is Scott Lambert. I am a partner in the Dubai office of Beale Co. I am joined today by our experienced associate, Sadaf Habib, in presenting this webinar. This webinar will give the construction sector our perspective on the present position in light of current UAE government directives, which continue to exclude construction as an essential business sector other than for health and safety directives. Also, construction will have been affected by sites which are located within the Al Ras area in Dira, given the recent lockdown directive for 14 days there. We've also been talking to clients and passing on experiences from what we've been seeing and have seen in the market and from what our clients have been telling us over the past several weeks. We have over 150 people attending today from across the globe, but in particular from the Middle East region. The interest in this webinar and the attendees today speaks for itself. As I mentioned, we are looking at 4 practical scenarios, one each from the perspective of the main contractor, the employer, the consultant being a project manager, and the subcontractor supplier. In these scenarios, we'll consider the issues from the perspective that the underlying contract is an unamended FIDIC 1999 Red Book or 2006 White Book. We do acknowledge that in almost all cases, these contracts are heavily amended, so that what we say may vary according to the amendments that have been made for any particular contract, should we be giving advice on any matter. Before we get into the scenarios, I want to briefly consider some of the relevant clauses that affect this issue. First of all, from the FIDIC Red Book 1999. First, we have subclause 4.8, which deals with safety procedures and which places safety obligations on the contractor to comply with all applicable safety regulations and to take care for the safety of all persons entitled to be on the site. These obligations need to be read with the more specific obligations in subclause 6.7. Subclause 6.7 places squarely on the contractor an obligation to maintain the health and safety of all persons, and importantly, to make suitable arrangements for all necessary welfare and hygiene requirements and for the prevention of epidemics. Next, we move to subclause 8.3, which relates to programming issues. The key points of this subclause are that it requires an updated program whenever the progress of the work falls behind the accepted program. Secondly, the subclause requires the contractor to give to the employer an early warning notice of specific probable future events or circumstances which may adversely affect the work, increase the contract price, or delay execution of the works. Next, we have subclause 8.4, dealing with entitlement to an extension for the time for completion. This subclause relevantly provides that the contractor shall be entitled, subject to subclause 20.1, to an extension of the time for completion if and to the extent that completion for the purposes of subclause 10.1 takeover is or will be delayed by the following relevant clauses. Paragraph B gives an entitlement for a cause of delay, giving an entitlement to extension of time under a subclause of the general conditions. This could include force majeure, change of law, and delays by authorities. Also, paragraph D, where there are unforeseeable shortages in the availability of personnel or goods caused by epidemic or governmental actions. This subclause is frequently heavily amended to change entitlements and to impose additional record keeping and mitigation obligations. So you need to read the EOT clause in your contract in each case. Now we come to subclause 8.5, which relates to unforeseeable delays by relevant authorities. This will apply where A, the contractor has diligently followed the procedures laid down by the relevant legally constituted public authorities in the country. B, these authorities delay or disrupt the contractor's work. And C, the delay or disruption was unforeseeable. Then this delay or disruption will be considered a cause of delay under paragraph B of subclause 8.4. However, is this subclause really applicable to these circumstances, given that all three limbs have to be satisfied? SADF will consider this further. Then we have subclause 8.8, which empowers the engineer to suspend the works. The contractor must follow this instruction. The impact of this suspension will depend on the reasons for it and its duration. Where the suspension is not due to the fault of the contractor, then the contractor may be entitled to claim costs and an extension of time. Next, we have the change of law clause of subclause 13.7, which entitles the contractor to claim for additional time and cost where there is a change of law. It provides that the contract price shall be adjusted to take into account any increase or decrease in cost resulting from a change in laws made after the base date, which affect the contractor and the performance of obligations under the contract. The base date is normally the date of tender. The change has to be to the law of the country and not just a law anywhere that impacts on the works. A major focus of discussion that has occurred surrounds clause 19 and force majeure. There are 4 prerequisites for force majeure, being an exceptional event or circumstance which is beyond a party's control, which such party could not reasonably have provided against before entering into the contract, which, having arisen, such party could not reasonably have avoided or overcome, and which is not substantially attributable to the other party. Then there is a non-exhaustive list of events that may comprise force majeure, which does not include epidemics. This list is important as it affects entitlements to cost claims under subclause 19.4. It is important to note that just because an event is a force majeure event for subclause 19.1, we must still meet the requirements of subclause 19.2, being that the event prevents the performance of obligations under the contract. The subclause also does not apply to an obligation by either party to make payments. This means that each project may be different, and COVID-19 may be a force majeure on one project, but not the project next door. Also note the 14-day notice time frame. This clause will be investigated further in the scenarios. In the event of a force majeure event and the relevant notices having been given, the contractor's entitlements are in subclause 19.4, other than where the right to terminate for prolonged force majeure arises under subclause 19.6. As you can see, the entitlements to cost are fairly limited to those matters expressly stated in subclause 19.1. Again, it is noted that epidemics is not on that list. A well-known but vital subclause 20.1 is next, which requires a notice of claim. If the contractor considers himself to be entitled to an extension of time for completion and/or additional payment under any clause of these conditions or otherwise in connection with the contractor shall give notice to the engineer describing the relevant event or circumstances giving rise to the claim. The notice shall be given as soon as practicable, but not later than 28 days after the contractor becomes aware or should have become aware of the relevant event or circumstance. If the notice is not given within the 28 days, the entitlement to claim for additional time or additional cost may be lost. We'll consider this later. Next, just a few of the white book clauses. First, we have subclause 4.4, which relates to where the services are impeded or delayed by the client or his contractors, so as to increase the scope, cost or duration of the services. It should be noted that it has notice and entitlements that follow. However, is this really a relevant clause? Again, we will consider that later. Then there is clause 4.5, where there are changes in circumstances for which neither the client nor the consultant is responsible, that make it irresponsible or impossible for the consultant to perform the services in whole or in part in accordance with the agreement. There is an obligation on the consultant to promptly give notice. Next, clause 4.6.1, give the client a clear entitlement to suspend services, which the consultant shall immediately comply. The entitlements of suspension or clause 4.5 notice are dealt with by clause 4.8, as the additional expense or necessary work is to be treated as exceptional services, and there is entitlement to additional time. Now that I've gone through some of the key clauses that we need to look at, I'll hand over to staff to go through the first two scenarios and see how these apply and what you should do.
Thank you, Scott. Let us now look at our first scenario. The scenario applies the unamended FIDIC 1999 Red Book conditions of contract. As the main contractor on a large mixed-use commercial project, you are currently behind program and have an outstanding yet unresolved extension of time claim. However, one of your laborers has been diagnosed as having COVID-19, and the UAE government has ordered the indefinite quarantine of the labor camp in which your entire labor force is housed. This is the only labor camp in the UAE subject to such a limitation. What are the main contractor's rights and obligations? The relevant clauses for the contractor to consider are subclause 8.3, submitting a revised program to notify, subclause 8.4d, which allows the contractor to claim extension of time for unforeseeable shortages in the availability of personnel or goods caused by epidemic or government actions. Subclause 8.5, delays caused by authorities, which entitles the contractor to claim for EOT under subclause 8.4b. Subclause 13.7, adjustments for changes in legislation, and clause 19, force majeure. Key points for the contractor to consider are: is the contractor under a duty to notify under subclause 8.3? What impact will the lockdown of the accommodation have on the work to be carried out? Is it going to affect the critical path? Is there alternative labor readily available for the lockdown period? What effect will any delay be relevant, given there is an ongoing pre-existing delay to the critical path? What are the contractor's entitlements as to time, money, or both? You will recall, as Scott explained earlier, subclause 8.3 of the FIDIC Red Book requires the contractor to give prompt notice to the engineer of specific probable future events or circumstances which may adversely affect the work, increase the contract price, or delay execution of the works. As the first course of action, the contractor should notify the engineer of the UAE authorities' quarantine of the labor camp at the soonest and assess the impact this will have on the construction program. The FIDIC standard conditions do not penalize the contractor for failing to give such notice under subclause 8.3. However, to avoid the employer raising this point later, especially if the issue escalates into a dispute, it is advisable for the contractor to give such notice. Further, Article 246 of the UE Civil Code requires parties to act in good faith in their dealing. This is an implied obligation that requires parties to deal honestly and fairly in their transaction. A notice under subclause 8.3 would assist the employer to better prepare for possible delay to the completion date. It is likely that a failure by the contractor in issuing such a notice would be seen as the contractor's failure to act in good faith. Subclause 8.3 also mandates the contractor to submit a revised program whenever the previous program is inconsistent with actual progress or with the contractor's obligations. The closing of the labor camp is likely to affect the construction program. Before submitting the revised program, the contractor should consider any delay for which it may be responsible and if the subsequent delay due to COVID-19 has any impact. The contractor should therefore submit a revised program taking into account its historic extension of time claim and the expected delay from closing the labor camp. The contractor should be mindful of this because the program forms the baseline for assessing compensation. If the program is not up to date, then the contractor may prejudice its claims and receive less than what it would have been entitled to had the program been properly updated. So our contractor has issued its initial notice under subclause 8.3 to preserve its entitlement on extension of time and cost. So what next? The contractor should consider whether the delay caused by the quarantine of the labor camp gives rise to an extension of time and cost claim. For this, the contractor can consider relying on the following possible clauses. The contractor with its legal advisors should assess which clause or clauses give it the strongest entitlement. We will start by looking at the contractor's possible entitlement to extension of time and cost under subclause 8.4d. Under subclause 8.4d of the FIDIC Red Book, a contractor is entitled to an extension of time if completion of the works is or will be delayed by unforeseeable shortages in the availability of personnel or goods caused by an epidemic or governmental actions. The contract defines unforeseeable as means not reasonably foreseeable by an experienced contractor by the date for submission of the tender. In our scenario, because of the outbreak of COVID-19, the contractor can no longer deploy its own labor to site. However, to rely on this provision, the contractor will have to show that this is an unforeseeable shortage in the availability of personnel. The contractor should therefore consider if there is indeed a shortage of personnel and if it can obtain an alternative supply of labor. The contractor should also assess if this would increase the contractor's cost in any way, and if there is a shortage, was the shortage of labor unforeseeable. The quarantine order has been issued only on the contractor's labor camp. It is arguable that the contractor could potentially outsource labor from another supplier and therefore mitigate the situation. Under UAE law, whilst there is no express duty to mitigate, to avoid the contractor to arguably be in breach, it is advisable for the contractor to first seek an alternative supply of labor to see if there is a shortage. Where the contractor is able to source labor, it is possible this may be at a higher cost. In such a case, the contractor should consider relying on subclause 13.7, change in law, in making its claim for additional cost. I will discuss this provision shortly. Where the contractor is unable to obtain alternative labor and there is a shortage in the market, the contractor may consider relying on subclause 8.4d for its extension of time claim. However, as discussed, a key issue for the contractor in bringing its claim under this subclause is ensuring that the shortage of labor was unforeseeable. The World Health Organization declared COVID-19 a pandemic on 11th March 2020. This was more than 2 weeks before one of the laborers contracted the virus and the UAE government quarantined the contractor's camp. The contractor could argue that the outbreak of such a virus was not foreseeable at the time of entering into the contract, and neither was the impact that this would have on supply of labor. However, the contractor should check that it took measures to prevent the outbreak in accordance with its obligations under subclause 6.7 and any other measures imposed by the authorities to avoid potentially losing its right to claim. So can the contractor claim under subclause 8.5, delays caused by authorities? For the contractor to rely on subclause 8.5 to claim extension of time, he would have to show that, firstly, the procedures, if any, laid down by the authorities to combat COVID-19 were followed in the labor camp. Secondly, the contractor's work is being delayed or disrupted because of the government's quarantine of the labor camp. And finally, the government's action of quarantining the labor camp was not foreseeable at the time of tender. The contractor could argue that the government's action of quarantining the labor camp could not have been foreseen at the time of entering into the contract. The challenge for the contractor in relying on this provision is to show that it properly complied with the health and safety requirements under the contract in accordance with subclauses 4.8 and 6.7, as earlier highlighted by Scott, and as well as any requirements that the government imposed for COVID-19. To the extent that there were additional requirements because of COVID-19, the contractor could consider claiming for these as an additional cost under subclause 13.7. If the contractor wishes to rely on subclause 8.4 and 8.5, it should issue a timely notice of its claim in accordance with subclause 20.1. That is, it should issue a notice within 28 days of becoming aware of the quarantine of the labor camp. Notably, subclause 8.4 and 8.5 only entitle the contractor to claim extension of time. A claim for cost is not included, but this, of course, does not prevent the contractor from raising such a claim. The contractor may rely on Article 389 of the UAE Civil Code to claim prolongation costs. The next two provisions, subclause 13.7 and clause 19 force majeure, that will be discussed, entitle the contractor to claim cost as well as time. The contractor should carefully consider to what extent, if at all, it can rely on these provisions to strengthen its cost claim. To rely on subclause 13.7, the contractor would need to consider whether the UAE government's order to indefinitely quarantine the labor camp can be considered a change in legislation and entitle the contractor to extension of time and cost under this provision. Subclause 13.7 allows for the contract price to be adjusted either upwards or downwards where there is an increase or decrease in cost arising out of change in the laws of the country or in the judicial or official government interpretation of such laws. The contract defines laws as means all national or state legislation, statutes, ordinances, and other laws and regulations and bylaws of any legally constituted public authority. The UAE government's order on the quarantine of the labor camp appears to have arisen out of Article 15 of Federal Law No. 14 of 2014 on the control of communicable diseases. This article allows the Ministry of Health to order the closure of any place to prevent or limit the spread of any communicable disease. The COVID-19 virus would likely be considered a communicable disease for purposes of this law. The order issued by the authority would need to be properly examined to consider whether it amounts to a change in law of the kind envisaged in subclause 13.7. The contractor should receive legal advice on this point before raising a claim. The position may have been clearer had the government issued an order halting construction projects throughout the country because of the pandemic. For example, as Scott mentioned earlier, the Al Ras area of Dubai has been closed for 2 weeks from yesterday. A similar order would make the contractor's claim under subclause 13.7 clearer. So what about force majeure? Since the outbreak of COVID-19, there has been a lot of discussion on whether this pandemic constitutes an event of force majeure. Is it an act of God? Is it an event beyond the party's control? Most practitioners agree that it is arguable that COVID-19 could be a force majeure event, subject to the wording of the force majeure clause in the parties' contracts and the specific governing law. In our scenario, we will examine the unamended Clause 19 of the FIDIC Red Book Conditions of Contract. You will recall subclause 19.1 of the contract provides that force majeure means an exceptional event or circumstance which is beyond a party's control, which such party could not reasonably have provided against before entering into the contract, which, having arisen, such party could not reasonably have avoided or overcome, and which is not substantially attributable to the other party. Subclause 19.1 goes on to provide a non-exhaustive list of events that could be considered exceptional events or circumstances amounting to force majeure. The first step for the contractor claiming force majeure is to establish whether it is a force majeure event that falls within subclause 19.1 and that he has been prevented from performing his contractual obligations in that performance has become physically or legally impossible as opposed to more difficult or unprofitable. Epidemics are not explicitly covered under subclause 19.1. But it is arguable that the outbreak of COVID-19 is exceptional in its extent and nature and beyond a party's control. Subclause 19.1 lists natural catastrophes such as earthquake, hurricane, typhoon, or volcanic activity as exceptional events constituting force majeure. It may be arguable that the outbreak of COVID-19 is a natural catastrophe and a force majeure event. However, this may not be a strong point given the kinds of natural catastrophes listed in the clause. Is the UAE order quarantining the labour camp a force majeure event? Depending on the nature of the order, it is arguable that it is a force majeure event under the contract because it is an action by an authority and outside the party's control. Article 273 of the UAE Civil Code addresses force majeure as follows. In contracts binding on both parties, if force majeure supervenes, which makes the performance of the contract impossible, the corresponding obligation shall cease, and the contract shall be automatically cancelled. In the case of partial impossibility, that part of the contract which is impossible shall be extinguished, and the same shall apply to temporary impossibility in continuing contracts, and in those two cases it shall be permissible for the obliger to cancel the contract provided the obligee is so aware. While the UAE Civil Code does not provide an exhaustive list of force majeure events, the UAE courts have taken a narrow interpretation of force majeure clauses to date. The established non-binding but persuasive case law provides that the fundamental requirements for a force majeure event are: firstly, the event must have been unforeseeable. Secondly, it must amount to more than just a hardship. Thirdly, the event must have been unavoidable. And finally, it is beyond the defaulting party's control. You will note that the requirements for force majeure under UAE law and subclause 19.1 are similar. In our opinion, COVID-19 is likely to be considered a force majeure event if the contractor can prove that the effects amounted to more than just a hardship and rendered performance of obligations under the relevant contract impossible until the COVID-19 crisis is over. However, at this point, there is no government order that has stopped all construction work. The order issued is limited to the quarantining of the labour camp. The contractor should also consider, could the party have reasonably provided against the force majeure before entering into the contract? It may be arguable whether or not the contractor could have prevented the outbreak of COVID-19 in the labour camp. Subclause 6.7 of the contract obliges the contractor to ensure that suitable arrangements are made for all necessary welfare and hygiene requirements and for the prevention of epidemics. COVID-19 is a pandemic, and the employer could argue that the contractor should not be entitled to extension of time and cost because it did not exercise adequate measures preventing the outbreak in its labor camp. Before claiming force majeure, the contractor should ensure it took all necessary steps required in preventing the epidemic and complied with any requirements issued by the authorities for COVID-19. This is to avoid the contractor losing its right to claim force majeure. For example, if the 2-meter distancing rule was not followed on site and an outbreak occurred, it would prejudice the contractor's claim. It may be difficult to prove that the actual cause of the epidemic was due to the failure to follow these requirements, because it may be that the relevant people got infected because of another of the contractor's personnel in the same camp facility. Lastly, the contractor should consider, is the contractor being prevented from performing any of his obligations under the contract by reason of force majeure? At this stage, the contractor could argue that the outbreak of COVID-19, generally with the social distancing requirements and closure of public spaces, together with the specific quarantining of its labor camp, is preventing the contractor from carrying out its obligations, and that this is a force majeure event. Subclause 19.2 of the contract requires the party relying on this provision to issue a notice within 14 days of becoming aware of such an event. The consequences of force majeure are set out in Subclause 19.4 and entitle the contractor, subject to Subclause 20.1, to claim extension of time for any such delay and payment for cost. As a general point, before submitting an extension of time and cost claim, the contractor should consider whether it is already in delay or if there was a cause of delay because of which it may not be entitled to an extension of time. This would be because the contractor's progress has not been affected. Alternatively, depending on the extent of any historic delay, the delay in cost arising could be proportionately shared between the contractor and employer. So to recap, the contractor in our scenario should take the following actions. The contractor should issue a notice under Subclause 8.3, alerting the engineer of the quarantine and the likely effect on the contract price and works. The contractor should consider past delay events and issue a revised program under Subclause 8.3, taking into account its previous extension of time claim and any delay because of the quarantine. In submitting its revised program, the contractor should consider if the delay from the quarantine of the labor camp affects its critical path. The contractor should check if it complied with all the required health and safety procedures and if it acted in accordance with subclauses 4.8 and 6.7 of the FIDIC Red Book and any other requirements by the authorities to avoid losing its right to claim. The contractor should keep detailed records and carefully evaluate the impact of the labor camp being quarantined by looking at alternative sources of labor and if the situation can be mitigated. Where the contractor is claiming for extension of time under subclause 8.4b or D, or under subclause 13.7, the contractor should, in accordance with subclause 20.1, issue a notice no later than 28 days after it became aware or should have become aware of the event. In accordance with subclause 20.1, such a notice should be followed by a detailed claim, which should be issued within 42 days after the contractor became aware of the event or circumstance. The contractor could also consider issuing a notice of force majeure under subclause 19.2, especially because subclause 8.4 does not provide an automatic entitlement to cost. Before issuing any notices, it is advisable for the contractor to seek legal advice to ensure its rights are properly protected and the notices are appropriately worded. In our second scenario, we consider a situation from the employer's perspective. The scenario applies the unamended FIDIC 1999 Red Book. As a developer, you are strongly aware of the government's advice about social distancing and the closure of places where large groups of people congregate. You are concerned about the possibility of a COVID-19 outbreak at one of your projects, and you're concerned not only for the health of people, but also about your social responsibility and brand being diminished. You want work to stop at your sites for 14 days, following similar closures of courts and other establishments, and also to have stricter new working rules followed by the contractor to minimize the risk of an outbreak. What can you do under the contract and what are the risks? The relevant clauses for the employer to consider are Subclause 4.8, Safety Procedures, Subclause 6.7, Health and Safety, Subclause 8.8, Suspension of Work, Subclause 13.7, Adjustments for changes in legislation, and finally, Clause 19 on force majeure. The key points for the employer to consider are: can the employer suspend works under the contract? What are the risks with suspending works under the different provisions? Can the employer require the contractor to follow stricter working rules? Subclause 8.8 of the contract allows the employer to suspend progress of work at any time for any reason. It provides an unrestricted right to the employer to suspend works and does not require the employer to provide a reason for suspension. The employer should consider the consequences of suspending under Subclause 8.8, which would be, during any period of suspension, in this case 14 days, the contractor retains liability for the works and is responsible for protecting, storing, and securing such part of the works against any deterioration, loss, or damage. If the contractor suffers delay and/or incurs costs as a result of complying with the notice to suspend, Subclause 8.9 provides that the contractor will be able to submit a claim notice and will be entitled pursuant to Subclause 20.1 to an extension of time for any delay if completion is or will be delayed and payment of costs. The contractor will also be entitled to payment of the value as of the date of suspension of plant and/or materials which have not been delivered to site on certain circumstances. The employer should appreciate that suspending the works under Subclause 8.8 will mean that it will be liable for the contractor's standing costs during the period of suspension, and if the period of suspension exceeds the initial 14 days, these could be substantial. If the suspension continues for more than 84 days and the contractor still cannot proceed with the works, the contractor may, by notice under Subclause 8.11, treat the suspension as an omission of the affected part of the works. Okay, looking at force majeure. Alternatively, the employer may consider force majeure under Clause 19. However, before taking action under this provision, the employer should consider if the outbreak of COVID-19 is a force majeure event under Subclause 19.1. In a similar way to our previous discussion of the contractor claiming force majeure in our first scenario. So as previously discussed, it could be argued that the outbreak of COVID-19 is a force majeure event. The employer should consider the operation of the force majeure provision. Subclause 19.2 states that the party that is prevented from performing its obligations under the contract can issue a force majeure notice. In our scenario, it does not appear that the employer is prevented from performing its obligations. In fact, Subclause 19.2 states that force majeure does not apply to any obligations of payment. So in any case, the employer would be required to make any payments due to the contractor. Further, under Subclause 19.4, the contractor could bring a claim for extension of time and cost in accordance with Subclause 20.1. If progress of work is prevented for a continuous period of 84 days because of force majeure, then either party can terminate the contract. On termination, the engineer would determine the value of the work done. It will be simpler for a contractor to trigger the force majeure provisions because the current global circumstances surrounding COVID-19 are more likely to make it impossible for the contractor to perform its contractual obligations. In such circumstances, the contractor is required to give notice of force majeure, and then, as described above, the works will be temporarily suspended until the effects of COVID-19 have subsided and have stopped affecting performance of the contractor's obligations. However, as an initial step, the employer could write to the contractor to check if the contractor is complying with its obligations under Subclause 4.8 and 6.7 and any additional measures imposed by the authorities considering the outbreak of COVID-19. You will see this on the next slide. Subclause 4.8 of the contract requires the contractor to comply with all applicable safety regulations and take care for the safety of all persons entitled to be on the site. Therefore, the employer could remind the contractor of its obligation and to take added measures for COVID-19 in accordance with government guidelines. Subclause 6.7 of the contract, the contractor is required to ensure it has in place health and safety measures to prevent epidemics. However, the contractor could potentially claim for additional costs arising out of these measures under subclause 13.7. The employer could ask the contractor to maintain detailed records about its workforce and why they're unable to work. That is, self-isolation, infected, or lockdown due to imposed restrictions. The contractor is required to maintain records in any case under subclause 6.7, but the employer could require these to be more strictly enforced. The employer could consider taking these steps first before suspending the works or discussing with the contractor the possibility of issuing a force majeure notice. This would give the employer time to assess the situation with COVID-19 and may be less costly than opening itself to the contractor's claims. So to recap on the actions that the employer can take, the employer can remind the contractor of its health and safety obligations under the contract. The employer can regularly review records from site and closely monitor the situation. If it becomes necessary to suspend works, consider whether suspending the works for 2 weeks under subclause 8.8 will be appropriate, and then reevaluate the situation after 2 weeks. If the situation escalates, discuss with the contractor force majeure and the prospect of the project being completed on time. I will now hand over to Scott to take you through the rest of the scenarios.
Thank you, Siddharth. Thank you for your insights into those two scenarios. Now I'll look at the third scenario involving a consultant who is a project manager. I know there are many other activities consultants undertake. However, we do not have time to cover all types of consultants, and the project manager is possibly the consultant who is most directly affected by COVID-19. Scenario 3 with the consultant. Applying an unamended FIDIC 2006 White Book. As a project manager on site, you are concerned about the work progressing and the risk to your site staff. However, the client instructs you to demobilise and the project is to be suspended for 1 month as the contractor has suspended work claiming COVID-19 risk. What are your rights and obligations under the agreement? The relevant clauses from the FIDIC White Book 2006 are subclauses 4.4, 4.5, 4.6 and 4.8. Points to consider. Just one moment. There is no government order that all work on construction sites must cease. In fact, the government directives continue to list construction as essential business exempt from directives. What rights does the client have to suspend the operation of the services? The consultant clearly cannot continue delivering the services as envisaged by the agreement, given the main contractor is not doing any work. Does the consultant actually have any obligations to the client? So looking at these issues, as noted earlier under clause 4.6.1, the client can suspend work. The effect of the notice is immediate and the consultant should comply and minimise cost. In the event that the client gives a notice under clause 4.6.1, the consultant should be entitled to an extension of time to perform the services and to make a claim under clause 4.8. I mentioned clause 4.4 earlier. It would also be arguable that clause 4.4 should apply as it relates to where the services are impeded or delayed. This is the case where the services are suspended by a client's instruction. In this case, there is an obligation on the consultant to notify the client of the circumstances and probable effects for which the consultant is to be paid as additional services and to have time to perform those services. However, it is arguable that when you read the agreement as a whole, that clause 4.4 applies where there is a client cause which impedes or delays the services other than a suspension. Clause 4.8 specifically references suspension and deals with the effect of a suspension. Therefore, it is arguably a more appropriate clause, and clause 4.4 should not be used. Clause 4.4 arguably relates to other issues that may cause delay, for example, late instructions or approvals, changes in drawings, failing to provide access. Clause 4.5 is a significant clause in this issue. This clause applies where circumstances arise for which neither the client nor the consultant is responsible, and which makes it irresponsible or impossible for the consultant to perform in whole or in part the services in accordance with the agreement. Clause 4.5 is the closest clause in the agreement to a force majeure clause, may actually be broader. As an aside, there is now an exceptional circumstances clause in the 2017 White Book, which is similar to the 1999 Red Book force majeure clause. The issue of an initial reading of the clause suggests that clause 4.5 operates as a force majeure clause. However, the notice is to come only from the consultant to the client and not from the client to the consultant. So notice from the client cannot be given under this clause, and the client only has the right to suspend. The issue of the breadth of the clause needs to be considered, in that it applies where it would be irresponsible for the consultant to provide the services. As the consultant is obligated to perform the agreement in good faith, as discussed earlier by Sadaf, I suggest that it is strongly arguable that it would be irresponsible for the consultant to continue with the delivery of the services and keep all staff engaged on a project when there is clearly a significantly reduced work requirement due to the contractor not doing any work. It is also strongly arguable that the consultant should promptly give a notice under clause 4.5 that it is irresponsible to perform the services, and to not do so would be a breach of the agreement. Clause 4.8 operates under clause 4.5 circumstances, or where the services are suspended by the client under clause 4.6.1. The consultant is in these cases entitled to claim for any necessary work or expense as exceptional services, and to additional time and payment for performing the services. Given this, would the client be in a better position giving a notice to the consultant, informing of the clause 4.5 circumstances and requiring the consultant to issue a notice under clause 4.5, and that if the consultant did not do so promptly, the client reserves its rights? Given that clause 4.8 covers both circumstances, the practical effect of the client giving notice to suspend rather than seeking to have the consultant give a clause 4.5 notice may not be apparent on the immediate rights to time and money, as clause 4.8 applies in both cases. There is also no difference to the longer term effect, as the right to terminate for prolonged suspension under clause 4.6.3 does not distinguish between a clause 4.5 event or a suspension under clause 4.6.1, where the effect is that the suspension is for more than 182 days. Also note that under the White Book there is no time bar in the agreement along the lines of subclause 20.1 of the Red Book. Although I do note that the consultant's obligation under clause 4.5 is to give notice promptly. If notice is not given promptly, the consultant is in breach of the agreement, and this may reduce the amounts which the consultant can recover or time for an extension which the consultant may otherwise be entitled. So actions. As with all matters, records. The consultant should give effect to the suspension and immediately endeavour to minimise cost. Keep records of all costs and actions taken to justify any claims under 4.8 as exceptional services or for additional time. Both parties should make a diary note of the date of suspension and 182 days later in case the consultant may consider exercising the right to terminate. There is no right to such termination for the client for prolonged suspension. The client has a right under clause 6.1.1 to terminate on giving 56 days notice. The consultant should make a claim for exceptional services and additional time under clause 4.8 when next invoicing. Scenario 4, the subcontractor supplier. This is the most difficult of the scenarios to give a standard answer on, as the forms of subcontract are not standard, nor is the wording of the back-to-back provisions contained in them. In looking at this scenario, I also want to minimise going over the same ground previously covered by Sadaf. The scenario is that applying a back-to-back contract to a FIDIC 1999 Red Book with usual clauses importing main contract provisions, for example, not to cause breach, paid when paid, etc. You're on a critical path piece of work, and the materials which are required are unable to be delivered due to the factory in Europe having been affected by the employer voluntarily ceasing work for a 2-week period due to COVID-19 concerns. What are your rights and obligations to the main contractor? Would the situation be different if the government in the country of the factory ordered a closure or announced a special public holiday covering the period? Or what if the work was not on the main contractor's critical path? Relevant clauses. Clause 5, nominated subcontractors. I have not mentioned this clause earlier, as these clauses are often amended and vary considerably. Subclause 8.3, program. Subclause 8.4, extension of time for completion. Subclause 8.5, delays caused by authorities. Subclause 13.7, adjustments for changes in legislation. Clause 19, force majeure. And subclause 20.1, contractors' claims. Points to consider. The subcontractor supplier is not producing materials due to overseas factory closure in light of COVID-19. Let's examine the subcontractor's position where the works involved a critical path and when they are not. Let's also examine the situation where the supplier is nominated and where the factory closure is mandated by the government in the country where the factory is located. As with the discussion on the main contractor scenario, the issue of material shortage should entitle a claim to be made under paragraph D of subclause 8.4. The employer of the factory producing the item ceasing operations due to COVID would not have been foreseeable. Many subcontracts, however, will only entitle an extension of time to the extent that the main contractor is given a corresponding extension of time. In this scenario, there is a strong likelihood that an extension of time may be granted given the subcontractor's work is on the critical path. However, where the main contractor may have another cause of delay for which it is responsible, maybe one caused by another subcontractor, and therefore the main contractor is not entitled to an extension of time. In those cases, the subcontractor may have no entitlement. There is a need to check the wording of these back-to-back clauses carefully, as they do vary and can have harsh consequences. The issue of alternative supply needs to be investigated. If an equivalent good is readily available, the subcontractor may have no claim. Depending on the goods, there may be a time delay in any event with procuring an alternative, particularly where the work is critical path. This may still allow for an extension of time, even where the alternative supply is secured. Keeping records of the endeavours made to mitigate the impact of this event is advisable. A claim notice would have to be made and given within 28 days under subclause 20.1. If the work is not on the main contractor's critical path, the subcontractor's position is even more difficult. If the work is not on the main contractor's critical path for the works as a whole, the usual back-to-back clause will reference only delay causing completion to the works not being achieved by the time for completion under the main contract, and therefore the subcontractor will have no relief in either time nor money. If the supplier was nominated, this may create a complication. Under usual nomination clauses, there is a right for the subcontractor to reject the nominated subcontractor. In such a case, the subcontractor would take full responsibility for the nominated subcontractor, and the usual rules, as we have discussed, apply. However, if the subcontractor had no choice when engaging the nominated subcontractor, it will be arguable that the delay in supply is the main contractor's risk, and that notwithstanding any other delay by the main contractor, the subcontractor may still be entitled to an extension of time due to the factory closing. As discussed earlier in scenario 1 with main contractors, force majeure would seem to apply to these circumstances. The subcontractor could claim time and not cost under subclause 19.4. However, the issues with this time claim will be the same as I just mentioned. The claim will be under subclause 8.4b and still has to be assessed and determined. There is also the further complication of the exact wording of the back-to-back clauses. Would government forced closure of the factory improve the subcontractor's position? Subclause 4.5, as discussed earlier, will provide relief when authority causes an unforeseeable delay. However, this subclause does not apply as it only relates to relevant legally constituted public authorities in the country. The country is normally where the site is located. Similarly, subclause 13.7 may be a potential source of relief for the subcontractor. However, it applies only to a change of law in the country. Unlike the main contractor scenario, this change of law happened in another country. The subcontractor is therefore in no stronger position given the factory was closed by government order in the country of the factory. In future, consideration should be given to these clauses where there is a component of the work reliant on supplies that are not located within the country. Actions. The subcontractor should try and mitigate the effect of the unavailability of supply and keep records of those endeavours. The subcontractor should give early warning notice under subclause 8.3 of the delay event, and if required, provide an updated program. Also, the subcontractor should give notice under clause 19.2 within 14 days of becoming aware that the factory has been temporarily closed. And finally, the subcontractor should give notice under subclause 20.1 claiming a delay under clause 8.4d within 28 days of becoming aware that the factory has been temporarily closed and the supply shall be affected. Again, all of these actions will depend upon the particular circumstances and the wording of the particular subcontract, including the back-to-back provisions. Some final thoughts. I hope that you found these scenarios useful. As would be expected, our actual advice would always be subject to the specific project and the specific contract. The consequences of this pandemic can be severe. So we can only say be aware, be alert, and get your legal advice now. As a final thought for today, if you do need support on COVID-19 and other project advisory issues, you may be interested in Beale Co's in-house lawyer service. This virtual service provides you with access to any member of the contracts and project advisory team as if you had an in-house counsel helping you on your projects. The advice is commercial, frank and direct and rapid. The The rate card involves a significant discounted hourly rate compared to our standard hourly rates, which with much flexibility over a period of a retainer. Details of the service are on the slide. Please do contact us if the in-house lawyer service might be of interest. It remains me to say thank you for joining Sadaf and I this afternoon. Apologies that we've run out of time and we haven't been able to answer all the questions raised by this webinar. We will get back to you on any questions that you have submitted. Keep safe and I suppose follow your contract. Thank you. Goodbye.